Hello, everybody. My name is Richard Epstein, and along with Mario Rizzo, I'm a director of the Classical Liberal Institute, an institute whose general mission is described as trying to figure out how it is that you deal with a system of limited government and strong property and contract rights. Now, the difficulty, of course, with this particular provision is all of these rights often run into conflicts with other sorts of rights and interests. And when there are high conditions of uncertainty about the effects of certain kinds of technologies, there's always going to be introduced some kinds of a balancing test to figure out what particular technologies can be used, how they can be limited, and what can take place with respect to them. One of the technologies that gives rise to this particular problem is the question of facial recognition. And the conflicts of this one, I think, seem pretty clear right on its face. On the one hand, you could imagine how these technologies could be of vital importance to detect and to stop criminal activity, to help you find missing persons, and to do all sorts of things with respect to various kinds of investigations that may or may not have criminal significance. On the other hand, you have to keep databases which are fairly exhaustive, which have the identity of individual people, so that there's a privacy interest on the other side. And so the question that you ultimately have to face is, what solution do you want to kind of balance these two interests? Do you want to ban the technology, which seems extreme? Do you want to allow it to be used completely without limitation? Seems extreme. And then you try to figure out what's going to go on in the middle, and it turns out that you have a lot of uncertainty. So the clear solutions are wrong and the right solutions are elusive. That's why we put together this particular panel to deal with all of the kinds of issues that we're facing with. And the panel is going to be chaired by Hank Perritt. And we have two sessions. The first one's going to be with Adam Schwartz and Floyd Abrams. Second one with Stephen Feldstein and Richard Clarke. I'm not going to read their impressive resumes because I'd rather have the time devoted to the discussions in question. And without further ado, I'm going to turn it over to Hank, who is now going to orchestrate the procedure. Hank, it's all yours.
Okay, thanks very much, Richard. It's a pleasure to be involved in this this morning. We have some great people, and I know that we're going to have some great discussions. As Richard said, face recognition technology has provoked a good deal of controversy over the clashing of interests that people perceive. I hope as we go through our discussions today that we will identify some different uses of face recognition technology that may warrant a different treatment by law. And in our two panels, I think we're going to be able to explore the use of face recognition technology domestically by law enforcement and intelligence agencies, and also globally, which raises some different issues. First on our panel is Adam Schwartz. Adam is a senior staff attorney at the Electronic Frontier Foundation, EFF. He has represented travelers subjected to warrantless smartphone searches, dissidents seeking to speak up in government social media, and customers of phone companies that unlawfully sold location data. He's filed amicus briefs addressing the right to record on-duty police, perpetual location tracking of court-involved people, face surveillance by corporations of consumers, and overbroad laws against so-called cyber stalking, among other things. So, Adam, we're looking forward to hearing from you.
Great. Thank you very much. I am very honored to be here among such distinguished panelists and with all of the sponsors of this event, so thank you for having me. Face recognition technology is a special menace to our privacy, racial justice, free expression, and information security. Our faces are unique identifiers, and most of us expose them wherever we go. Unlike our passwords and identification numbers, which we can change, we can't change our faces. So governments and businesses, often working in partnership, are increasingly using our faces to track our whereabouts, activities, and associations. Fortunately, people around the world are resisting. A growing number of communities have banned government use of face recognition. As to business use, many communities are looking to a watershed Illinois statute, which requires businesses to get opt-in consent before extracting a person's face print. EFF is proud to support laws like these. Let's begin with the ways that face recognition harms us. Then we'll turn to solutions. Face recognition violates our human right to privacy. Surveillance camera networks have flooded our public spaces. Face recognition technologies are more powerful by the day. Taken together, these systems can quickly, cheaply, and easily ascertain where we've been, what we've been doing, and who we've been with, all based on a unique marker that we cannot change or hide, our own faces. Government use of face recognition raises Fourth Amendment concerns. In recent years, the US Supreme Court has repeatedly placed limits on invasive government uses of cutting-edge surveillance technologies. This includes police use of GPS devices and cell site location information to track our movements. Face surveillance can likewise track our movements. Face recognition also has an unfair disparate impact against people of color. It has caused the wrongful arrest of at least 3 Black men. Their names are Michael Oliver, Najir Parks, and Robert Williams. Every arrest of a Black person carries the risk of excessive or even deadly police force. The technology also caused a public skating rink to erroneously expel a Black patron. Her name is Lamia Robinson. These cases of mistaken identity are not anomalies. Many studies have shown that face recognition technology is more likely to misidentify people of color than white people. A leader in this research is Joy Buolamwini. Even if face recognition technology was always accurate, or at least equally inaccurate across racial groups, it would still have an unfair racial disparate impact. Surveillance cameras are over-deployed in minority neighborhoods, so people of color will be more likely than others to be subjected to face printing. Also, history shows that police often aim surveillance technologies at racial justice advocates. Face recognition is just the latest chapter of what Alvaro Bedoya calls the color of surveillance. This technology harkens back to lantern laws, which required people of color to carry candle lanterns while walking the streets after dark, so police could better see their faces and monitor their movements. In addition, face recognition chills and deters freedom of expression. The First Amendment protects the right to confidentiality when we engage in many kinds of expressive activity. These include anonymous speech, private conversations, confidential receipt of unpopular ideas, gathering news from undisclosed sources, and confidential membership in expressive associations. All of these expressive activities depend on freedom from surveillance because many participants fear retaliation from police, employers, and neighbors. Research confirms that surveillance deters speech. Yet, in the past 2 years, law enforcement agencies across the country have used face recognition to identify protesters for Black lives. These include the US Park Police, the US Postal Inspection Service, and local police in Boca Raton, Broward County, Fort Lauderdale, Miami, New York City, and Pittsburgh. This shows again the color of surveillance. Police might just as easily use face recognition to identify the whistleblower who walked into a newspaper office, or the reader who walked into a dissident bookstore, or the employee who walked into a union headquarters, or the distributor of an anonymous leaflet. The proliferation of face surveillance can deter all of these First Amendment protected activities. Finally, face recognition threatens information security. Data thieves regularly steal vast troves of personal data. These include face prints. For example, the face prints of 184,000 travelers were stolen from a vendor of US Customs and Border Protection. Criminals and foreign governments can use stolen face prints to break into secured accounts that can be opened by the owner's face. Indeed, a team of security researchers did this with 3D models based on Facebook photos. To sum up, face recognition is a threat to privacy, racial justice, free expression, and information security. Before moving on to solutions, let's pause to describe the various types of face recognition. It all starts with face printing. This automated process translates the visible characteristics of the face into a unique mathematical representation. 2 uses of face prints are most familiar. Face identification compares the face print of an unknown person to a set of face prints of known people. For example, police may attempt to identify an unknown suspect whose face was caught on a surveillance camera by comparing their face print to those in a mugshot database. Face verification compares the face print of a person seeking access to the face prints of people authorized for such access. This can be appropriate. For example, many people use face verification to unlock their phones. While passwords provide stronger protection, some users might not secure the devices at all without the option of face verification. There's much more to face recognition. Face clustering, tracking, and analysis do not necessarily involve face identification or verification. Face clustering compares all face prints in a collection of images to one another to group the images containing a particular person. For example, police might use face clustering to create a multi-photo array of a particular unidentified protester, then manually identify them from a mugshot book, while in a case where manual identification would have been impossible based on a single photo of that protester. Face tracking follows the movements of a particular person through a physical space covered by surveillance cameras. This could be a store interior or city downtown. For example, police might use face tracking to follow an unidentified protester from a rally to their home or car, then identify them with an address or license plate database. Face analysis purports to learn something about a person by scrutinizing their face. Developers claim this can determine a person's demographics, like race, and their emotional state, like anger. Such analysis will often be wrong, as the meaning of a facial characteristic is often a social construct. For example, determining a person's gender based on their face print will often misgender people who are transgender or non-binary. To the extent the technology works, it may be used for racial profiling. For example, a Chinese company has developed face analysis it says can work as a, quote, Uyghur alarm, close quote. Finally, automated screening to determine whether a person is supposedly angry or deceptive can cause police to escalate their use of force or expand the duration and scope of a detention. Yet the US Department of Homeland Security is working on a program called FAST that purports to use facial features as evidence of so-called, quote, malintent, close quote. Legislators must address all forms of face recognition, not just the familiar identification and verification, but also the less often spoken of clustering, tracking, and analysis. So turning to solutions. EFF supports a ban on government use of face recognition. The technology is so destructive that government must not use it at all. EFF has supported successful advocacy campaigns across the country. Many local communities have banned the government use of face recognition, from Boston to San Francisco. The state of California placed a 3-year moratorium on police use of face recognition with body cameras. Some businesses have stopped selling face recognition to police. We also support a bill to end federal use of face recognition, sponsored by Senator Markey and Representative Jayapal and many others. There may be appropriate exceptions from a federal or a governmental ban for government employees unlocking devices with their faces. Corporate use of face recognition also harms privacy, racial justice, free expression, and information security. Part of the problem is at brick and mortar stores. Some stores use face identification to detect potential shoplifters. This often relies on error-prone, racially biased criminal justice data. Other stores use it to identify banned patrons, but this can misidentify innocent patrons, especially if they are people of color, as happened to Lamia Robinson at a roller skater rink. Still, other stores use face identification, tracking, and analysis to serve customers targeted ads or track their behavior over time, which invades everyone's privacy. There are many other kinds of threatening corporate uses of face recognition. Some companies use it to scrutinize their employees. Other companies, like Clearview AI, use face recognition to help police identify people of interest, including Black Lives Matter protesters. Of all the laws now in the books, one has done the most to protect us from corporate use of face recognition, the Illinois Biometric Information Privacy Act, or BIPA. At its core, BIPA does 3 things. First, it bans businesses from collecting or disclosing a person's face print without their opt-in consent. Second, it requires businesses to delete the face prints after a fixed time. Third, if a business violates a person's BIPA rights by unlawfully collecting, disclosing, or retaining their face print, the person has a private right of action to sue that business. We support a law sponsored by Senator Merkley to establish a BIPA at a federal level. BIPA prevents one of the worst corporate uses of face recognition, dragnet face printing of the public at large. Some companies do this to all the people entering a store or all people appearing in photos on social media. This practice violates BIPA because some of these people have not previously consented to face printing. People have filed many BIPA lawsuits against companies that took their face prints without their consent. Facebook settled one case for $650 million, arising from that company's tag suggestions feature. Other BIPA lawsuits have been filed against Clearview AI. This is the company that extracted face prints from 10 billion photographs and uses these face prints to help police identify suspects. The company does not seek consent for its face printing. So Clearview now faces a BIPA lawsuit in Illinois State Court brought by the ACLU and several similar suits in federal court. In both venues, Clearview asserts a First Amendment defense. EFF disagrees with that and has filed amicus briefs saying so. Our reasoning proceeds in 3 steps. First, Clearview's face printing enjoys at least some First Amendment protection. It collects information about a face's measurements and creates information in the form of a unique mathematical representation. The First Amendment protects collection and creation of information because these often are necessary predicates to free expression. For example, the US Supreme Court has ruled that the First Amendment protects reading books, gathering news, creating video games, and even purchasing ink by the barrel. Likewise, appellate courts protect the right to record on-duty police. All of these cases involve the creation and collection of information, but not the expression of information. First Amendment protection of face printing is not diminished by its use of computer code because code is speech. To paraphrase one court, just as musicians can communicate among themselves with a musical score, computer programmers can communicate among themselves with computer code. Second, Clearview's face printing does not enjoy the strongest form of First Amendment protection, such as strict scrutiny. Rather, it enjoys just intermediate scrutiny.
You've got about 3 minutes left, Adam.
Great, thank you. This is because Clearview's face printing does not address a matter of public concern. The Supreme Court has emphasized this factor in many contexts, including wiretapping, defamation, and emotional distress. Likewise, lower courts have held that common law claims of information privacy, namely intrusion on seclusion and publication of private facts, do not violate the First Amendment if the information at issue was not a matter of public concern. Intermediate review also applies to Clearview's face printing because its interests are solely economic. The Supreme Court has long held that commercial speech, meaning expression related solely to the economic interests of the speaker and the audience, receive lesser protection. Thus, when laws that protect consumer data privacy face First Amendment challenge, lower courts often apply intermediate judicial review under the commercial speech doctrine. To pass this test, a law must advance a substantial interest, and there must be a close fit between the interest and what the law requires. Third, the application of BIPA to Clearview's face printing passes intermediate scrutiny. As discussed earlier, the state of Illinois has strong interests in preventing the harms caused by face printing, including, again, racial justice, privacy, free expression, and information security. Also, there is a close fit from these interests to the safeguards that Illinois requires, opt-in consent to collect the face print. In the words of the Supreme Court, data privacy requires, quote, the individual's control of information concerning their person. Some business groups have contested the close fit between BIPA's means and ends by suggesting Illinois could achieve its goals with less burden on business by requiring just an opportunity for people to opt out. But defaults matter. Opt-out is not an adequate substitute for opt-in. Many people won't know a business collected their face print, let alone how to opt out. Other people will be deterred by the confusing and time-consuming opt-out process. Thus, numerous federal appellate and trial courts have upheld consumer data privacy laws that are similar to BIPA against First Amendment challenge. Just this past August, an Illinois judge rejected Clearview's First Amendment defense. So to very quickly sum up, face printing compared to other forms of high-tech surveillance is a special threat. And as a result, EFF supports a ban on government use of face surveillance with narrow exception for employees unlocking their own devices. And we support BIPA type laws that require opt-in consent for private entities to use face surveillance. It's an honor to be here, and I'm looking forward to hearing from the other speakers.
Our second speaker is Floyd Abrams. Mr. Abrams is a senior counsel at Cahill, Gordon, and Reindel LLP's litigation practice group. He has substantial national trial and appellate practice and extensive experience in high visibility matters, often involving the First Amendment, securities litigation, intellectual property, public policy, and regulatory issues. He's argued frequently in the Supreme Court of the United States and enjoys praise from both sides of the political aisle. He filed an amicus brief and presented argument in the Supreme Court on behalf of Senator Mitch McConnell. And he's been described by Senator Daniel Patrick Moynihan as the most significant First Amendment lawyer of our age. Floyd?
Good morning. It's good to be here. And I very much appreciate the chance both to be heard and to participate in this exchange of views. I do represent Clearview in the Illinois case and some other matters that Mr. Schwartz referred to a moment ago. I thought I'd start by talking about why it is that law enforcement entities, and those are the entities with which Clearview is working, law enforcement entities are their clients. Why in the world is it necessary or advisable, or why do law enforcement agencies want information of this sort? Let's just run through a few of the sorts of information that federal law enforcement agencies have sought as a result of facial recognition technology in general and the use of Clearview in particular. January 6th, it is a good idea, isn't it, to find out who was there, who participated in the insurrection on the steps and then indeed inside the Capitol. And both federal and state law enforcement authorities have used Clearview to help in that effort. And help it has been. The FBI has used, excuse me, Clearview in that respect as well. The U.S. Secret Service, U.S. immigration authorities have used Clearview to help identify perps and victims in domestic and international child exploitation cases. And there are many child exploitation cases that state entities have sought to get help in. I mean, there's a whole dark internet on which the most egregious, outrageous, and criminal misbehavior is shown, sometimes by parents of the children who they have abused. It's not a misuse of state power to try to identify the guilty people in those situations. The U.S. Postal Authority has used Clearview to identify people who steal mail, to identify people who have sought to commit arson on and in U.S. post offices. U.S. immigration has used Clearview to identify people who routinely cross the border and then recross the border. There are lots of situations in which I would have thought that it was a shared value to find out, I hear my phone ring, excuse me, who has committed crimes of this sort. So this is not simply a tale of a peering, over-aggressive, intrusive, biased government. I mean, these are appropriate uses, and when they're inappropriate, of course, they should be abandoned and limitations placed. Mr. Schwartz referred to the First Amendment, and indeed I have spent a good part of my career arguing with respect to and hopefully for the application of the First Amendment. These cases, the cases in Illinois and the like, are all at relatively early stages. And while we've had one opinion to the contrary, as Mr. Schwartz mentioned, I mean, the reality is there is a body of First Amendment law in which has led the Supreme Court to say in so many words that the creation and dissemination of information is protected by the First Amendment. That's what the Sorrell case said. That is the holding of the Sorrell case in the Supreme Court in 2011. And it makes sense. I mean, the First Amendment is not limited to newspapers. The First Amendment includes on a far broader level information and its collection and its creation. Now, what Clearview does is to use photographs which have appeared on the public internet. I use the word public deliberately. There is a way to speak on the internet in private, to speak in Facebook in private. We're talking here about photos that are public photos put on the public internet, available for all to see and all to read and look at. And what Clearview offers is a way for law enforcement agencies to see if there's a match between photos that have appeared in this public forum on Facebook, say, and suspect in cases. There's nothing wrong with that. I get the argument that there can be a misuse of any form of new technology, but the notion that there ought to be laws and statutes, limitations on the use of public information in the way that critics, at least, have suggested, seems to me to go too far by an enormous amount. A final point. I'm not going to argue law today with Mr. Schwartz. I don't think that's really helpful as to whether intermediate scrutiny or strict scrutiny is used. Obviously, that's a central issue in all First Amendment cases. But it is worth saying that what we're talking about here is photographs of people taken, put in a public place where all can look at them, and those photographs being used for further identification. I mean, if my client hired 5,000, 10,000 people to try to compare photographs which exist to photographs that the police have of a possible suspect, and remember what is often the case there is not a full face picture, but somebody running, moving, newspaper over face, etc. That you know, in that situation, very commonplace, and certainly the case with respect to the January 6th insurrection, the use of public photographs to determine, excuse me, if people who are suspected of criminal conduct is entirely proper. And to sum up, where it is not proper, where there are racial issues, and there have not been about Clearview, but if there are racial issues, of course they should be dealt with. And of course, the police or whoever else may be involved in it should be required to deal with that. that happens not to be a problem, to have been a problem with my client. And I simply wind up by saying this: my client aside, the use of facial technology in a way which allows people who have committed the most serious crimes to be apprehended is a social good, not something to be avoided, barred, and punished. Thank you very much.
Thank you very much, Floyd. Let me ask you, Adam, if it's clear that you want fairly broad restrictions on this technology. And as I've thought about this, I struggle with how one should understand both the right to privacy and consent in the public sphere. Obviously, First Amendment law has developed predominantly around the reasonable expectation of privacy. And people have assumed in many cases that if you put yourself or your face into the public sphere, that you no longer have a right to privacy, or conversely, that you have consented to various uses of the fact of your presence or your face. So how do you think we should understand these concepts differently in the face recognition technology context?
Sorry. As a society, we are struggling with the proliferation of new untrumpetive technologies that make it easier to document what other people are doing in public places. And it can't simply be that there's a right for the target of information collecting to veto everybody else's information collection by withholding consent, nor can it be that by walking out our door, we stand naked to the whims of every other person or entity to surveil us. And hard lines have to be drawn. For EFF, we draw a big distinction between taking a photograph, either in real life or scraping a photograph from the internet, the public-facing internet, activities that we think it's proper for people to do. We think we don't object to Clearview having scraped images off the internet, and we support a right of people to take photographs of on-duty police who are doing their jobs in public places. On the other hand, taking the face print from a face, whether it's a face you see in a public place or a photograph you scrape from the internet, that is a different activity. And the mere fact that you have shown your face in public in real life or on the internet does not mean that people should be able to to extract the face print. What makes the face print different is all the things I talked about before in terms of privacy, racial justice, free speech, et cetera. I would like to just respond briefly to one, I thought, really interesting point that Mr. Abrams made. And I just first want to say that one of the reasons I went to law school was because I was inspired by Mr. Abrams, and he's a longtime hero of mine, and I greatly appreciate all the work he has done. It's very interesting that with lots of technologies, we begin by saying we're only going to use this, in the words of Mr. Abrams, to address the most serious crimes. We hear that with technology after technology, whether it's taking DNA from people who are convicted or when we're going to use a cell site simulator. And then over a very short amount of time, we're not looking at murder and child exploitation. We're looking at immigrants and we're looking at mail theft, which I don't think by any metric are the most serious crimes. So there is always a tendency to mission creep once we say this should be in the toolbox. January 6th was mentioned, and certainly that is, for me, one of the most extreme crimes in our lifetime. EFF opposes the use of face printing to identify the January 6th insurrectionists. And that's not because we support them, but rather because we know that already in the last years of government use of face surveillance, it has been deployed far more times against Black Lives Matter than has been deployed against insurrectionists.
Other comments? Go ahead.
Oh, thank you so much. Look, I guess this is more to Adam, but when I start thinking about this and talking about bans, what I start to worry about are two kinds of errors. The first, the forced collection of information you shouldn't get, which you stress. And then when Floyd starts to talk, what he stresses is the collection of valuable information that serves a kind of legitimate purpose. And I think there is a kind of asymmetry between them. If you ban the information that you collect altogether, you can never redeem it. If you collect information that you ought not to collect, there is ex post punishments of one kind or another that you could give. So to me, the real question, I guess, is to both of you is, what's the relative frequency that we should expect between the cases in which this stuff is used for legitimate purpose as opposed to the illicit uses? And I don't see anything in either of you that have actually talked about the relative frequencies. I mean, if you give me 3 instances in which it turns out there's been a misidentification of some person, I think that is certainly a concern. But if there are 10,000 cases on the other side where crimes have been prevented or cured, I think that has to be in the equation. So what's the relative frequency? Listening to Adam, I think it sounds relatively low. You're talking about thousands upon thousands of uses, and you identify 4 or 5 cases, which could be handled individually. So the basic question is, how do you weigh the two kinds of error problem? And why is it that you think the frequency of abuse is so high that a total ban is going to be justified? And then I'd like to hear what Floyd has to say in response.
So the number of times that the government has used face surveillance to identify a suspect is not known to me. And that is in significant part because of, frankly, government secrecy about how they're using these technologies. What the public knows about this really just comes out in drips and drabs. So just for example, the General Accounting Office put out a report 2-3 months ago regarding the number of federal agencies that are conducting face recognition or that have contracts with companies like Clearview to do face recognition for them. But these reports don't state the number of times face recognition is being done. So in as much as what we want is a ratio of bad uses to all uses, the denominator is simply unknown. Now, EFF is supportive of transparency legislation in this space.
Adam, I think that has to be wrong. We don't know the exact number, but what you did is you indicate there's a widespread and pervasive use of these technologies by all sorts of people, custom immigration people, local police, the FBI, and major. That suggests to me that it's being used thousands upon thousands of times on a daily basis. Indeed, that frequency of use was one of the reasons why you were upset about it. So I can't tell you whether it's 100,000 times a day or 500,000 times a day, but I would be stunned if you looked at those over a year that you didn't scan 1 billion images. And then what you do is you're coming up with 4 cases. And so it seems to me that we don't want to sort of treat on agnosticism. We don't know what the precise ratio is, but from what you said and what from Floyd has said, it seems to me that the current use is high, and I take it as getting higher. And this, by the way, also leaves open the question about how many people use this privately, not to any particular client of Floyd's, but because they could get access to similar types of technologies on their own. So do you really think that that we have so little information about the base that we can't make any judgment about the relative frequency?
So let's assume that it's being used very, very frequently. What we know is that very frequent use includes identifying lower level crimes, and it includes immigrants. And we think it is not appropriate to use this kind of most invasive surveillance to address those kinds of law breaking in our society. Now, as to more serious crime, no doubt there have been people who have committed murder, people who have committed child exploitation, and the use of face surveillance may have helped break the case, have provided leads in order to identify the wrongdoer. But that is true of all manner of surveillance technologies that we think it's not appropriate for society to use because, or the government to use, because the burden on privacy, speech, racial justice, and the like is too excessive. Face surveillance is potentially a game changer compared to other surveillance technologies, again, because unlike other things that the government is using to track us, we show our faces everywhere and we cannot change our faces.
The police officers that I talk to tell me that when they're called to the scene of a robbery at a convenience store, very frequently they just have absolutely nothing to go on. And so the clearance rate of those crimes is very low. And the quality, when they do have an eyewitness, the quality of eyewitness identification is low. And they tell me that when they've had the opportunity to use face recognition technology, that the effect of that is to increase the accuracy of their investigation significantly. And to the extent that that's just anecdotal evidence, I understand that. But to the extent that that is a significant part of the universe of what we're dealing with here, I have a hard time understanding why we want to have an across-the-board ban for something that can improve the accuracy of law enforcement investigations, which would, if we improve the accuracy, we're going to reduce problems with racial profiling and that kind of thing.
Yeah, I'd like to add to that the misidentification problem is not a problem caused by the gathering of and the use of information, which, as you've just said, is a tool of the police. Now, sometimes they've misused it. 60 Minutes had a program a few months ago about this subject. And I remember thinking, well, 60 Minutes doesn't do a lot of programs about things that work. The I had a client once that said, sunshine is a weather report, a flood is news. And that's the way it was. And in that case, the police, I think in Detroit, had misused material provided to them. I mean, Clearview and whoever else is doing anything like what Clearview does, provides accurate data. Sometimes the objection to it is, that it's accurate and therefore, we can't walk around the streets anymore. But I just don't think that's reality. There is a way to use facial recognition techniques in a way which is destructive of human freedom. China does it. And so it is possible to use this technology for harm. But in this country, at this time, the balance, and I can't give numbers because there are no numbers about, how much of this and how much of that are around. But in this country, the idea of saying that the EFF opposed the use of using facial technology to identify the people who were the criminals, or maybe you could say worse, who were the people that threatened the very fabric of this country on January 6th, to oppose the use of that. What risk was there? What harm was done by that? And it was only for the public good. I don't doubt for a moment that any new form of technology can be used badly or to cause some sort of harm. But this is one which, so far as we know, has really helped. And a final point, I really do reject the notion that I like the post office example. Put aside that it's been used to find out who's trying to commit arson in the post office. Yeah, it's been used sometimes to identify people who have engaged in a process of stealing mail. No, that's not the worst crime of all, but it's an important social interest that we be able, to those of us who still write letters, to communicate in some sort of way without those private thoughts being gathered, stolen, etc. And I don't think that we should make a distinction as we speak today between the January 6th example and stealing mail for the purpose of saying, well, that was important. EFF is on the wrong side of that anyway, but saying that's important and the others are really that much less so. It's a useful tool. All it is a tool, and it's beneficial.
Could I invite the panelists to turn your attention a little more tightly to remedies? We know that Adam thinks that an across the board ban is a good remedy, but suppose you can't get that. Talk to us about the relative merits of things like disclosure under the Washington State statute, or more particularized disclosure in the discovery context of criminal discovery in a particular case, warrant type requirements, and if that seems a desirable direction to move in, how should we understand probable cause? And there may be other certification requirements. There may be a very long list.
So I'll just jump in. Assuming hypothetically that there was going to be a regulatory approach to government use of face surveillance, the obvious template would be Title III and its regulations of wiretapping, where we have a warrant requirement, where we have limitations to more serious offenses, where we have a minimization requirement in terms of what's collected and stored, where we have disclosure to the accused, where we have criminal penalties for police who break that, where there's a private right of action. I think it's pretty straightforward, how you would regulate a technology like this. But to be clear, EFF believes that the threat of face surveillance is much greater than the threat of wiretapping. Everybody can see, I'll strike that, the little EFF sign, above my head there. And this has been characterized a little bit as a EFF position about banning, but this is a much broader thing than that. So we have 20 communities across the country, big cities like Boston and San Francisco have done this. They have said, we're not going to let our government officials use face surveillance because we view this as too dangerous. The entire state of California is living under a 3-year moratorium on any police officer in the state conducting face surveillance in connection with images captured by body-worn cameras. That's a vast number of images that the people of California have said cannot be used with face surveillance in our state. We have multiple senators and Congress people, including Markey and Jayapal, who are endorsing right now legislation to ban use of face surveillance by the entire federal government. And in fact, also by state governments using certain federal funding streams. So this is not an EFF position. This is a widespread position in the privacy and racial justice communities across the country.
I just wanted to add to that part of the conversation. It seems to me the question ought to be, is what is being communicated public in its nature or not? Photos on Facebook are by their nature public. Revenge porn is not. There are categories of speech which are unprotected by the First Amendment, and rightly so. But when we're talking about material which is protected, I think we really ought to proceed with great care about the adoption of legislation of any sort, banning, punishing the use of what I should emphasize are truthful information. I mean, it's worth saying when we talk about the First Amendment that there are a lot of interesting cases in libel about and other areas. How much do we protect falsity for the greater good of living in a free society? But a core First Amendment desire, effort has been to facilitate truthful speech. And the speech we're talking about here today is by its nature truthful speech. Now, to some extent, the very adoption of privacy law raises issues because very often under privacy law, we're saying privacy is so important in this area that even though the speech is true, and indeed, because the speech is true, we won't allow it to be disclosed without imposing sanctions. But that's not the sort of thing we're talking about here. When you're talking about gathering information with respect to criminal conduct, I would have thought that, subject to criticism of this or that in the conduct of the police, that it would at least be agreed that it is a public good to combat crime and to gather information which allows those who have committed crimes to be apprehended and punished.
And so we'd like to proceed into our second panel. And leading off will be Stephen Feldstein. He's a senior fellow in Carnegie's Democracy, Conflict, and Governance program. He was Deputy Assistant Secretary in the Democracy, Human Rights, and Labor Bureau in the United States Department of State. He's published research on how artificial intelligence is reshaping repression, the geopolitics of technology, and China's role in advancing digital authoritarianism. Stephen?
Great. Well, thanks for having me. I apologize I wasn't able to make the first part, the first panel, but I'm glad to be here now and looking forward to the discussion and the questions. So I will speak for about 10 to 12 minutes, kind of lay out some ideas regarding facial recognition, how to think about it, what are the kind of national security, global implications to the technology, and then hand it over and go from there. So why don't I just start? I think one of the key things when it comes to thinking about facial recognition technology is just how much the field itself, the technology has transformed. And the fact is that it has become increasingly ubiquitous around the world. In just the last 5 years, facial recognition has become widely adopted and has also significantly improved its accuracy. So while there remain efforts to prohibit facial recognition technology and its use by governments, law enforcement, I really think the train has left the station. And so where we seem to be right now is to figure out what's the most viable path to determining where there are legal and regulatory vulnerabilities and how to best respond. I think generally the global picture for facial recognition technology is mixed. A legal-based approach that carefully considers safeguards and balances public order interests with privacy protections is an appropriate framework to think about when it comes to democracies. But many adopters globally either have undeveloped rule of law frameworks or authoritarian contexts without adequate safeguards. And because facial recognition ultimately represents a major intrusion on privacy, as well as a potential infringement on political freedoms, its use in weak democracies and autocracies, I think, raises profound concerns. So one of the issues I've written extensively about when it comes to facial recognition, alongside other digital repression techniques, is to what extent they have transformed the ability of authoritarian states, think China and Russia, to collect information on citizens, track their whereabouts, particularly individuals of interest, and even to impose digital gulags and other sorts of fairly chilling environments in areas such as Xinjiang in China. So I think one of the insights, I wrote a book on the rise of digital repression worldwide earlier this year. And one of the insights from the book is that no technology, whether it's facial recognition, censorship, filtering, and blocking, other kind of internet controls, no technology exists in isolation. Technologies are a product of the political environments in which they reside and are linked to underlying forms of repression. So to that end, the key to properly addressing and confronting facial recognition technology, whether in democracies or autocracies, and this is particularly relevant in autocracies, isn't simply to build in more technical safeguards. I think that will only have limited utility, and it's important to consider the broader political context and underlying motivations political leaders have to exploit surveillance or other types of instruments in order to advance their political agendas. Let me turn to a few basic concepts when it comes to facial recognition. So I think facial recognition oftentimes gets lumped into a single category of technology used for surveillance and law enforcement purposes. In fact, techniques vary and they bring different implications. Facial recognition is a form of biometric ID, and it uses computer-generated filters to transform face images into numerical expressions that can be compared to determine similarity. Filters are usually generated by deep learning algorithms, and that's where you kind of get the artificial intelligence aspect to facial recognition. So basic uses of facial recognition, of which we're probably all familiar, is verification. So confirming whether a person is connected to a specific identity record. And that's something as basic as taking your iPhone, using facial recognition in order to unlock it. You also have, in addition to the verification purpose, you have the identity purpose. And often that can be one-to-one, or that can be one-to-many. And essentially what that asks is, does a record for an unknown individual exist among a larger database? And so an example of how identity, the identity purpose may be used is in police lineups, or used for casino blacklists, or used to identify individuals coming from mass protests. And then finally, there's a kind of third area, facial characterization, where it asks, what assumptions can I make about a particular face? This is oftentimes lumped in together with facial recognition, but really it's sort of a separate category of use. It's one that's controversial and really unproven when it comes to the technology, but essentially what it tries to do is use software to classify a single face according to its gender, according to certain factors. It could be gender, age, emotion, or other characteristics. This is something that you're seeing a lot of experimentation in countries like China, but again, it's controversial. It's not well founded in terms of actually being accurate, but it is an area that continues to gain interest. So 4 areas linked to facial recognition that I want to sort of hone in on more specifically in terms of concerns. So one is, this kind of links to what I mentioned, is when you have facial recognition technology that contributes to a broader digital surveillance repressive apparatus. And so you see this incorporated in safe city models. That could be in China. That could also be something incorporated in the Moscow metro in the context of protests, crackdowns, and recent elections. But you also see these types of safe cities and these sort of networked facial recognition surveillance cameras installed in areas like Kampala in Uganda, in Serbia, in the Gulf states, in Pakistan, in Central Asia. And so this is where, if you're sort of kind of looking at a spectrum of where there are greatest concerns linked to facial recognition, it is in these contexts where I think there's the most sinister effects. Next, you have areas where you have facial recognition that isn't directly part of a digital apparatus per se, but it does contribute to an overall chilling effect in a suppression. And so where you don't necessarily have direct abuses that are recorded with facial recognition, but it is part of a state effort to intimidate and silence dissent. And so the Philippines is a good case in point where there is the government is procuring a major system for Metro Manila from the Chinese government that will ostensibly incorporate facial recognition. But there are a lot of questions about what that's actually going to be linked to what extent it'll actually be used. Thailand is another example where there's a bit of security theater in terms of this facial recognition that is in place. which is in part used to intimidate individuals as much as it actually is, has a direct purpose that's incorporated. Third is facial recognition that's not per se part of a repressive agenda, but operates in a weak rule of law environment and is prone to abuse, where there's few opportunities for remediation, accountability, or safeguards. And so I think of weaker democracies in this context. So Mexico, Brazil, South Africa, Kenya, India, they all come to mind where there isn't necessarily a direct linkage to a repressive agenda, but where there is a consistent pattern of violations of privacy, human rights, and so forth, and where I think there should be, large concerns about lack of a regulatory structure to sort of help mitigate the worst. And then finally, facial recognition deployed in liberal democracies where you do have strong rule of law. However, the regulatory framework for biometric technologies itself is inconsistent or weak, leaving the onus to law enforcement agencies to determine appropriate uses, oftentimes varying by jurisdiction. I think a good example of how this sort of inconsistent framework is currently being applied relates to the United States. And you can look at one of the technologies or one of the companies that's been in the public view has been Clearview AI and U.S. police reliance on their methods. And so, this is where some of the questions come into play. Clearview is opaque about how it operates and where it scrapes its images and data from. There are major privacy questions. Certainly, there's no informed consent when it comes to the use of pictures that are scraped. Scraping may also violate platform terms of service, because we know that a lot of what is taken comes from Facebook, Twitter, other social media platforms. And then there's a lot of questions when it comes to transparency. How accurate is Clearview AI? Mostly we know anecdotal information taken from news reports about its accuracy. The company hasn't opened up its books for scrutiny. Are there false positives? What kind of bias is inherent in the methods that it employs? There's a real slippery slope of legal questions that I think results from that. I mean, I think another aspect more broadly when it comes to strong democracies with weak regulatory frameworks linked to facial recognition is that you have inconsistent rules that are applied that vary from jurisdiction to jurisdiction. In some places in the United States, facial recognition is banned completely. In others, there are certain privacy controls. In other jurisdictions, there's no real regulations at all. So a patchwork approach doesn't make for good policy and doesn't make for clear standards or guidelines. So what to do? There's an accepted standard generally for whether to use facial recognitions, particularly when it relates to surveillance, is justified on concepts of necessity, proportionality, and legitimacy. And I think it would behoove us to think more explicitly about how that links to different aspects of our legal framework that are being established. So when it comes to these principles, it essentially asks, is the measure, so is the technology necessary to achieve a legitimate aim? Does the measure represent a proportionate response to that aim? And is the action prescribed in law with sufficient precision and clarity? And so like any powerful technique, government use of facial recognition without proper legal controls and a solid basis can be problematic. And I would also note that facial recognition in general goes against a powerful principle in the human rights community, that of anonymity. So anonymity is important because it's, essentially, which is the acting or communicating without using one's identity in a way that protects the determination of one's name or identity. That's important because many people do not want things that they say to be connected to their permanent identity. They may be concerned about political or economic retribution, harassment, or even threats to their lives. So what anonymity allows for is for individuals to express unpopular opinions, honest observations, and to otherwise, otherwise to give rise to unheard complaints. So allowing individuals to avoid potential violent retaliation from those who they may offend plays a central role in exposing crimes and abuses of power. It's also the right to anonymity is linked to freedom of expression, Article 19, and rights to privacy. But facial recognition threatens this notion. At least in democracies, there are safeguards, which is why having a regulatory framework is so important. But in non-democracies, facial recognition is a major threat to citizen rights and directly challenges the notion of anonymity, particularly as we get to a world that has greater reliance on the digital and where facial recognition technology and its algorithms are becoming increasingly powerful. So why don't I stop there? One aspect we haven't touched upon, which I'd be happy to talk about in Q&A, are sort of the three broad approaches used in the United States in which to authorize government use of facial recognition, and how these are sort of varying by jurisdiction, but are starting to converge in a certain place. But I want to give time for Q&A. So I will stop there and look forward to the discussion. Thanks.
Thanks very much, Steve. Next, we'll hear from Richard A. Clarke. Mr. Clarke served for 30 years in national security policy roles in the United States government, first in the Pentagon, then in the State Department, and finally for a decade of continuous service for 3 presidents in the White House. In the White House National Security Council for President Bush, Clinton, and the second President Bush, he served as Special Assistant to the President for Global Affairs, National Coordinator for Security and Counterterrorism, and Special Advisor for Cyberspace. Mr. Clarke?
Hank, I think you left out the most important line in my resume, which is I received the Champions of Freedom Award from EFF. So Adam, thank you and EFF for that again. Appreciate that very much. I just want to pick up on where Stephen left off on the need for regulation. I am in complete agreement that we need regulation of the use of facial recognition by government, but also by the private sector. And I am in complete agreement. By the way, the private sector can do almost as much damage using something like this. I'm also in complete agreement that we need a national approach here in the United States rather than the patchwork quilt. This is really something that Somerville, Massachusetts, and Oakland, California, it's fine for them to stimulate debate by passing regulations, but we really do need a national approach that is going to have to be federal law or federal regulation. And what we need, among other things, is a standard for facial recognition technology. We don't know when facial recognition is being used by the private sector today or by governments today, whether or not the algorithms are any good. And we need to know that, and there need to be standards for use. That's true not only of facial recognition, it's true of artificial intelligence generally. Artificial intelligence is like facial recognition, a new technology that really doesn't have accepted standards, doesn't have accepted regulatory frameworks, and we need that. And it's kind of regrettable that the federal government hasn't stepped up and provided that. Anything, whether it's AI or facial recognition, or for that matter, fingerprints or hair samples, anything can be misused. And they have been. We know that even in the case of the famous, exalted FBI laboratory, facial recognition's used, but also fingerprints are used. And they have been misused over the decades. At the FBI, hair samples have been misused at the FBI lab. We need not only to have national standards, but we need to have someone auditing that organizations, particularly government organizations, that are using either AI or facial recognition, that they're using it up to those standards, and that the system is working appropriately. But any system in the hands of a authoritarian government, totalitarian government, or even an American federal agency can be abused. And we know that. We've seen it. We've seen it happen not only in Xinjiang, but we've seen it happen in the United States. Things are misused by governments if there is not proper oversight and proper standards. So I don't think what we're talking about here is unique to facial recognition. Stephen talked about tracking people using facial recognition. That's not how governments typically track people. They track them with their phones. They track them through a fusion combination of using inputs from mobile phone devices, automatic license plate readers, Metro passes, Easy passes, and they put all that information together. So tracking, again, is not unique to facial recognition. Facial recognition is a minor, I think, today at least, a minor component of government tracking people. Are there standards today that require warrants for some sort of tracking? Sometimes, in some jurisdictions. In other jurisdictions, tracking of some type can be done without any warrant or any judicial review. When I recently traveled through the EU, on departing Italy, I walked into a gate. Rather than talking to an immigration officer, I walked into an electronic gate. And that electronic gate asked for my passport to be put on a scanner. It opened. I then walked in. It closed behind me. I was locked into a little area between two gates, and I wasn't let out until I looked up at the camera and allowed that camera to do facial recognition of me and enter me into an EU database. Do I worry about that? No, actually, I was very pleased by that because it means next time I'm traveling to the EU, I'll be able to move more quickly through immigrations and customs. I've seen that elsewhere around the world, and I think we're going to be seeing it increasingly here in the United States. Airlines are already saying they're going to be using facial recognition to replace boarding passes. The Congress has been asking for years that the United States have controls on people leaving the country so that we know when someone has left, so that we know they're not overstaying their visa. In order to meet that congressional mandate, Homeland Security is now installing facial recognition systems at gates of international departures. We're going to see this everywhere. And therefore, there's a need to create standards and to audit those standards. But let's not make facial recognition, or artificial intelligence for that matter, some sort of evil. It is neither good nor bad. It's how it's used. And it's not in any way unique in that regard. Facial recognition can be misused. Artificial intelligence can be misused. Tracking people with their phones, fingerprints, hair samples, all of that can be misused in the absence of standards. They can also be used for good. If, for example, at the Boston Marathon bombing, we were able to use sophisticated AI and facial recognition technology from the camera feeds from the Lord & Taylor's department store, we would have been able to identify the people who, perhaps we would have been able to identify the people who did the bombing rather quickly. And perhaps if we had done that, some of the subsequent deaths that occurred, including tragically of the MIT police officer, would not have happened. Using facial recognition technology with AI under proper standards and proper auditing can do damage not only to terrorists, but to human traffickers and other forms of criminal activity. There's no reason, I think, to single out facial recognition and say that it is an evil when it is neither evil nor good. It is the governments that are evil or good. It's the standards that those governments create. It's whether or not the standards are audited and enforced. I know that the government of China now knows who I am, and I can't enter China or Hong Kong under any other name than this one because they've hacked their way into the government database of the Office of Personnel Management and stolen all of the records, including the photographs of anyone who ever had a top secret or code word clearance in the United States. That makes espionage a very, very difficult thing. It makes espionage almost impossible if you're trying to introduce people into a country under a false name. Is that good or bad? Well, I don't know. It's unfortunate if you believe the United States should have the ability to put agents into China or Russia. It's good if you want to keep foreign agents out of the United States. So I think what we can agree on here is that this is a new technology. It only really works in conjunction with AI and facial recognition in the United States should have standards. Those standards should be national. When those standards are agreed upon, there should be a system for auditing them to make sure that agencies and federal government agencies, and I think certain parts of the private sector that use them, particularly with regard to AI, should be doing so within a framework that we can all agree on, that is transparent and open. And that would apply to companies like Clearview, which I advise. It would apply to governments. And it would apply, I would hope, to uses even in places like university campuses, where facial recognition is now being used in some places to get into dormitories. So let me stop there.
Very good. Let me kind of kick off our Q&A session by asking you, Mr. Clarke, for clarification on your point about standards. You emphasize the need for standards for algorithms, but the face recognition technology develops algorithms from teaching databases. And as I understand the technology, if you have a lousy teaching database, you can have the greatest algorithm, your beginning algorithms to do the statistical analysis can be wonderful, and you'll still end up with garbage. So how would you think about standards for the teaching databases?
Yeah, you're absolutely right. I think with regard to AI generally, what we need is for the National Institute of Standards and Technology and the Department of Commerce, NIST, to run a process. You know, what NIST does, and it does it on encryption, it does it on all sorts of things. NIST opens up a panel to academic experts, not to government experts. It opens up a panel to well-regarded experts in academia. They then propose a standard for discussion. That discussion then goes on for quite a bit and is open to the public for rigorous comment and review. And unfortunately, perhaps in some cases, then this process takes a couple of years. But in the end, you have something that is developed not by government, used by government, but not developed by government. Open, transparent process. And I would do that with facial recognition. I would do it with AI in general. And it would certainly have to include, if we were talking about facial recognition, certainly have to include the training databases. Because we know training databases that are all white men don't work. But similarly, it turns out apparently in China, training databases that are all Chinese citizens don't work very well either when applied to the rest of the world. So I don't think there's a lot of mystery here about the technology. We know about the problems in training databases. We know about the problems with AI algorithms. We know about poisoning training databases. And it's something that NIST should be instructed either by the administration, by executive order, or by the Congress to do.
Very good. In the Q&A session that follows, let's proceed in this fashion. I promised Mr. Raskin and Mr. Rizzo, who had their hands up at the end of the first panel, that we would get to them. So I'd like to start with them. And then after that, let me ask for members of the audience to raise your hands. I think that the technology is going to let me see you if you raise your hand, and I'll call on you by name. As for the panelists, for either of the two panelists, you just feel free to jump in. And if that gets unwieldy, we can adopt some other approach. So Mr. Raskin, why don't we start with you?
Sure, thank you. So this question, in keeping with the previous ones, is for Adam from EFF. I guess I have my question is really about analogs to DNA testing and fingerprint testing. So much of what you say about racial disparities is also going to appear in DNA and fingerprinting. The more police you have in an area, the more DNA collection you're going to have in an area. So the more possibilities for matches are going to be in that area, at least according to that logic. And my question would be, you know, in the absence of a calculus, you know, it seems like you're unable, and I'm not saying this as a critique, but you guys have been unable to sort of say, these are how many cases have been solved, and these are how many cases of false positives there are, and making that calculus. In the absence of that calculus, it seems like there's some kind of preference for not having just a kind of blanket preference for not having facial recognition technology. And I wonder, how does that dovetail with having a preference towards fingerprinting and DNA? Is EFF's position that DNA itself and fingerprinting, it would be, I mean, the cat's out of the bag, but would your preference be for those things not to exist?
We don't oppose government use of fingerprinting or of DNA per se. We view face recognition as being a greater threat than those technologies because people can take measures as they go about their lives to limit exposure of their DNA and of their fingerprints. But for the vast majority of us, we show our faces. And even for people who are wearing partial masks, there is novel development of face recognition that can figure out who the face is based on parts of the face. So it simply is a greater potentiality of governments and corporations to easily, cheaply, quickly, universally track our movements with face surveillance compared to DNA and to fingerprinting. I would note, by the way, that DNA is a extractive example of the way that these technologies creep from limited use to much broader use. And this is true at least on two axes. The first is when we are putting people into DNA surveillance databases. At first, it was going to be people convicted of the worst crimes. And now in many states, it's people arrested for any felony or misdemeanor. So there has just been an extraordinary mission creep in the use of DNA to track people, which I think is instructive in what we think about regulating face surveillance. So for privacy advocates, when we hear people say, don't worry, we're only going to use face surveillance for the worst of the worst, and then a minute later, we're hearing we're also going to use it on immigrants and people who are stealing the mail. We've been in this movie before. We know that once it's allowed for some uses, it's going to expand for other uses. The other axis of DNA turning out to be much worse than we actually thought it was going to be is that initially we were told this was junk DNA, that it identified people but didn't tell us anything about them. But then it turns out the junk DNA actually can be used to make inferences about people and their genetic destiny, including their proclivity to having diseases. And we're concerned that in the same way, once the genie is out of the bottle on face surveillance, that there's going to be all kinds of other uses unanticipated from where we are now. Again, given the fact that all of us are showing our faces everywhere we go and can't change them.
Mr. Rizzo?
I think Adam just made the substance of my point, so I have no question now.
Okay. I'm going to pause here and see if anybody wants to jump in. And while I'm sort of temporizing vocally, if no one does jump in, I'm going to come back to Steve Feldstein because he promised us that he was going to comment on the 3 US control techniques. So maybe give it 2 seconds. Oh, I'm sorry, Professor Epstein, you had a point?
it seems to me that we need much more discussion of the way in which we sort of treat the intermediate solutions. What sort of ex ante protections we put into place, what sort of ex post protections we put into place than I have heard. I mean, the more I've listened to this, the more it seems to me that a categorical ban on this is not going to work. If I'm told that California has put it into place, my reaction is to say that has to be the worst mistake you could ever make, given the fact that there's complete disintegration in places like San Francisco and so forth in the way in which they run it. And so rather than talk about the extremes, what are the mechanisms that one would want to do at an intermediate level? To give you one thing that troubles me from what Adam said, I see no difficulty in using these technologies to deal with quote unquote minor criminal offenses if it turns out that the positive identification rate is extremely high and the relative harm is low. And so I don't understand why these limitations are. And when I try to figure out what it is that I would want to do, I can see that you might want to certify, you might want to go to a company like Clear Stuff and get some information about how they get their data and so forth. But by and large, it seems to me that the ex post remedies seem to dominate the ex ante remedies in this particular case, given the fact that we have lots of benefits. And on the racial question, I think, again, if you have decent racial identification and good tests on these things and can improve that, again, it seems to me, and I think I'm strongly disagreeing with what Adam has said on this thing, that the intermediate protections are what are needed. And Floyd might be able to tell us exactly what he thinks ought to be done on that particular situation. And it also is true about Richard, since both of them work on these particular cases. So I will leave it at that with a plea that we try to figure out how it is that we get into the middle of this thing in a more sensible way on doing the balancing.
I would just like to repeat and join the statement of Richard Clarke, which I think bears on this, to the effect that information of the sort that is gathered by artificial intelligence is, he said, neither good nor bad, and that we need standards for use. I mean, standards within the police for when to use, how to use, how best to make, to get the benefits of this new and ever changing, and I think in all likelihood improving technology. I think the problem with the EFF position, among others, is that as artificial intelligence gets better, and we have every reason to think it will improve in every way, the EFF position is that gives them greater concern. That to the extent that we have artificial intelligence, which is more correct, more usable, more relevant, that's a problem rather than a social gain. And I think that's incorrect. It's certainly not my view.
Stephen Feldstein, why don't you talk to us, as you promised, about the 3 U.S. Protections?
I'm happy to. I don't know if Adam wanted a chance to respond or not, but I'm happy to go forward.
Go ahead. We have ample time. He can respond later.
Okay. I do also want to say one thing on the idea of technology being neither good nor bad. I think the full statement attributed to Melvin Kranzberg was that technology is neither good nor bad, nor is it neutral, in the sense that the design choices you build from the outset oftentimes will determine in what direction it will actually be deployed. So if you think about the way that certain platforms, let's say WeChat in China, is developed, where you have specific design decisions in which to incorporate surveillance and censorship within how people communicate on the platform. Well, by itself, it's not necessarily meant to do harm, but because you are embedding certain values and principles in terms of the decisions and the architecture of the platform, it actually then veers towards an authoritarian objective. And so that's something that I always sort of bear in mind on these things. So very quickly then, in terms of what we've seen regarding kind of different approaches, I think you could sort of broadly look at kind of 3 different areas that states seem to be veering towards when it comes to the authorization of government use of facial recognition technology. So one is that you require operators within law enforcement, for example, to seek permission from a legislative body before purchasing or installing a facial recognition system. So as I understand it, there's proposed legislation in Arizona. In Washington state, there you need to file a notice of intent to install or use a facial recognition system. And this is kind of, I think, a growing area where more states are looking at this as a possible approach. Second is you authorize a small number of operations to use facial recognition technology. So, for example, you designate the state police in a jurisdiction, or the state agency that handles driver's licenses and IDs as the ones that are able to handle and use this technology. So all other agencies that seek to use facial recognition would need to submit requests to these authorized operators. And so what this does is it limits the pool, it creates restrictions, and it centralizes expertise. And as I understand it, Massachusetts and Utah are several of the states that have passed legislation along these lines. And then third is imposing judicial oversight. And so this would be requiring officers to obtain a warrant or a court order ahead of time before using facial recognition technology. And that's Massachusetts is a good example of where you're seeing that. But I think within all these different approaches, there's some kind of broader questions. So, one of which is, are we talking about ongoing facial recognition technology surveillance, or are we talking about accessing data collected by facial recognition? And then if we talk about data collected by facial recognition, is it certain data that's limited? So maybe images in a state driver's license registry. And then you could also look at it in terms of the restrictions on the collection instruments that are used. So you can only use data collected from body cameras, or you might want to put in restrictions limiting to what extent drones can conduct surveillance and to what extent that data can then be accessed. You could also have purpose restrictions. And so in the sense that, are there certain conditions or crimes in which facial recognition technology is authorized to be used? Should it only be used towards felonies? Should you broaden the aperture to other types of crimes as well? And then, of course, looking at transparency issues in terms of databases that are accessed, collection methods, vendors, auditing for accuracy and bias, something that Richard mentioned, perhaps making human review compulsory, as well as limitations on commercial use, which has also been described. So I'll leave it there.
Richard Epstein, I think your hand was up.
I took my hand down. I'm always happy to talk, but
Oh, all right.
I
Well,
think I had it up,
it was
and I
on
think
top of
others
you.
have a shot.
It was
I'd
on
like to
top
hear
of
what
your
Floyd
head.
says in response, or Mac.
I didn't know how to interpret that.
All right.
Well,
Oh, you just looked at my hand. That's because I'm a deep thinker.
okay. Well, let's focus on the possibility of a warrant requirement for a moment. And a couple of you have referred to that. And I think that the analogy was made to the Wiretap Act. I have trouble when I think about just porting that over to the face recognition context in interpreting some of the concepts. Take minimization, for example. Under the Wiretap Act, you can't get a warrant, you can't get an order for a Title III wiretap unless you can show that you are minimizing the conversations that you monitor. Well, that makes sense if you're talking about a communication stream, like a telephone conversation, or for that matter, an email exchange. But what does that mean in the face recognition context? Or for that matter, what is probable cause, a much broader concept? What does that mean in the face recognition context?
I'm assuming this question's directed at me, since I had put forward the title.
Anybody, go ahead.
So again, we want to not let the government use this at all. That's the EFF's position. If one was to take a regulatory approach, then Title III of the Wiretap Act is rock bottom the kind of regulations that EFF would want to say. We don't want police and prosecutors unilaterally deciding when they can use this. We want a case by case. We would want them case by case to get a warrant from a judge. I think probable cause is quite straightforward. Is there probable cause to think that a crime has been committed? And is there probable cause to think that the use of FR would generate relevant information to investigate that crime? And so the classic case would be you have the photograph of a person committing a mugging that was captured on a surveillance camera, and you don't know who that suspect is. You know there was a crime, and you know that using FR would help you get the suspect. In terms of minimization, I think that one oft-stated function of FR for public safety is there is a person suspected of planning to do something bad, and you want to watch for him in public places. And so minimization would be you have the smallest appropriate number of probe photos of that person who's going in, and you have the smallest appropriate period of time and geographic space where you're watching that person, depending on the scenario. So I think the porting of minimization over there is also appropriate. And finally, I think the porting of limitation to the more serious crimes is very important. Under the Wiretap Act, you generally cannot get a wiretap to investigate misdemeanor property theft, for example. It's only more serious crimes. Face surveillance is far more threatening to privacy than is wiretapping, and so we should have at least that kind of limitation in terms of what kind of crimes can be investigated by face surveillance.
I would just add a note that it seems to me that the idea of interposing criminal law limitations and the need for a warrant just doesn't fit a situation in which what we're talking about is the use and the examination of publicly displayed photographs. I mean, that is the starting point here. There are photographs, they exist. As a general matter of law, they are deemed to be public in nature. Anybody can look at them and make of them what they wish. And to start saying that because we have new technological advances, which allow us to enormously speed up the process of comparing those photographs with a search for a criminal or the like, that we should say we have to now import the notion of warrants. Seems to me, an enormous bit of overkill in this type situation.
I actually agree with what Floyd says. I think this is pretty clear. Right now, it's always a very tricky question to say what it is that constitutes a search that requires a warrant. So every time you go through TSA in order to get yourself onto an airplane, what you are is subject to all sorts of investigations, hands up, pockets emptied, and the like of that. I don't think anybody would want to say that you have to subject that kind of stuff to a warrant requirement. And indeed, I think every time you're engaged in mass surveillance, it is utterly inconsistent with the notion that you want to have a probable cause requirement in order to deal with the way in which you start to look at these kinds of things. And so what Floyd says, I think, could be made even more powerfully in this is if it turns out you've gotten yourself a technology that speeds things up and reduces error rate, what happens is it seems to me to be an unalloyed good that you ought to encourage rather than not. And in this particular case, if you can avoid erroneous identifications at a higher rate here than you can by using other techniques, what happens is I think people become more confident in their lives and are more willing to engage in activities that get closer to the edge because they think there's less of a chance they're going to be grabbed into this stuff. And, this is a situation today, and as best I could tell, it's also the case that this technology only gets better and that there are ways that we can improve it further. So I think the correct way to sort of run this stuff is a very different form of surveillance, is what happens is you let the thing run on the individual cases and so forth, And then what you do is, instead of looking at individual cases the way Adam thinks about it, what you do is every 3 months or 6 months, what you do is you have a kind of a generalized audit, not connected with any particular organization, to see if somebody could find some kind of structural mistake. To give you another comparison, and I'll leave it at this, when you try to figure out malpractice and do it through individual lawsuits, you always get everything all messed up, because you can't control, for the vast run of cases, the difficulty of the treatment, the expertise of the physicians, and so forth. And so if you're a hospital trying to figure out which doctors you want to encourage and which ones you want to discourage, what you have to do is to get the portfolio cases and to look at them at once rather than looking at them individually. And so the warrant requirement, it seems to me, in these situations actually puts you in the wrong direction by overemphasizing the particular when you really want the review to take place with respect to the systematic.
Boris Glasman has presented a question whether there's a concern that facial recognition technology will interfere with the Fifth Amendment right to confront witnesses, regardless of whether he's identified the correct amendment. There is concern that's been expressed about confrontation clause interests here. The way that the law enforcement people that I've talked to use face recognition technology in the crime scene instance is they'll get a face from the surveillance camera if they have one, and they'll run it against a so-called enrolled database, which most frequently I think comprises mugshots, but it might be broader than that. And then the computer program gives them not one, but several faces, a half dozen, a dozen, probably not more than a dozen. And it ranks those faces, the computer program ranks those faces as to the probability of a match. And then they use other investigative techniques. The police use other investigative techniques to narrow the field. They may be able to determine that somebody was out of the country. They may be able to determine that somebody else is dead, and so on. And then based on the combination of investigative techniques, they will call somebody in for further investigation, or they'll arrest somebody. And in no event, they tell me, is the computerized match used as evidence at trial. And so the confrontation clause argument is that the defendant is being deprived of the opportunity to challenge that out-of-court statement, that out-of-court identification. And without rehearsing all of the arguments back and forth about that, that's the issue as I understand it. So does anybody want to comment on that?
Yeah, look, my view about this is that the confrontation right should attach at trial. And during the period of investigation, you always have different kinds of standards. So to go through the traditional aspects of criminal law, when you want to start an investigation, you don't have to prove beyond a reasonable doubt. Even when you want to get a warrant, all you need is something like probable cause. And if this is a kind of a preliminary situation where there's grounds for correction later, then you have the following alternative. Either you don't lose something that's going to get you on to somebody, or you don't use it at all, or what you do is you use it and then give the protection later on. So to give you another kind of illustration, there are lots of questions in Fourth Amendment law as to whether or not you can have a dog sniff at somebody's house in order to get yourself a basis for a warrant. I think the answer is yes, you can do that. Then you get the warrant and then you go up. At each particular stage, I don't see where the particular abuse is. So in my view about this situation is the earlier you are in the process, the lower the level of protection that you're going to give, because what you do if you give too high a level of protection is you make investigation impossible. And so it's only after you targeted somebody having other stuff, this thing drops out because it's not going to be used as proof. I don't see what the difficulty is, because the evidence you're putting in at the end is exactly the same you would have if you'd gone to that final state by going through a different means. So I'm quite comfortable with that. And, you know, I regard myself as something of a civil libertarian. I'm not trying to sort of say here that you don't want the police, but generally speaking, the Fourth Amendment protections, I think, can much more powerfully attach after you start bringing charges. But in the original investigative stage, we are not quite sure who has done what. It's a kind of a quasi-emergency because evidence depreciates very rapidly in value. And if you start putting warrant requirements early on in these sorts of procedures, what you'll do is you'll have too many people who escape to commit other crimes against other innocent people.
Floyd Abrams, you had a comment?
Yeah, I just, listening to Richard and thinking back to a really interesting presentation earlier, sort of comparing America to the world, or fleshing out the different ways different societies deal with this. I was struck by the phrase that we have a strong democracy and weak regulation. That's a good thing. I mean, as a general proposition, why is that not a direction we should go in? Why should every state have to have the same regulations if we're going to have regulations? Why isn't this the sort of thing that we ought to leave to our notions of federalism in terms of state by state, but even more broadly, our notions of democracy and having weak regulations unless we absolutely need stronger ones. And I just don't think the case has been made for needing stronger ones.
Some people concerned about this right to confrontation have said that it would be enough simply to change the criminal discovery rules if they need to be changed, so that if the prosecution has used face recognition as an investigative technique, they have to disclose that to the defense and let the regular process take care of it from there. And presumably whether there is a right to confrontation at that earlier stage can be sorted out based on the arguments of defense and prosecution. Any reaction to that as a post hoc solution?
Again, I don't think it fits. It doesn't matter how the information was gathered for purposes of a criminal trial now, so long as obviously, not beaten out of someone or that. But if there's a tip, if there's some basis for looking harder at this rather than that, or this area rather than that, or this person maybe rather than that, the real question is guilt or innocence and fairness at trial with what comes out, not whether the police moved ahead even foolishly, let alone correctly, and wound up with the right guy, if it is the right guy, and those other limitations, beating and all sorts of other things, is not involved. I just don't see a basis for importing into the pre-arrest process of the sort of limitations on law enforcement that we're talking about.
Hello. Look, let me put it to you this way. If you're starting to talk about older technologies and you go way back to the time when the question in Katz was whether or not you could start to use wiretap on phone booths, the traditional distinction that was eventually made was that what you could do is you could basically tap to figure out who was talking to whom to get the connection. But what you could not do is to tap to figure out what the content was of the message. And that what you did is you took the first stage without a warrant. Once it turned out you knew what the connections were, you could then get other information in order to get the warrant and start to look at the content. It seems to me that that's perfectly sensible type of situation here. What happens is it's public information. You could start to look at it without any kind of warrant whatsoever. And then if it turns out that you now want to actually open up a particular phone call or get some kind of a document or a record, that's the time at which the warrant starts to take place. I generally think when it comes to the criminal law, a fairly safe proposition is that you don't change traditional rules that seem to have worked in classical areas for new technologies if in fact they have easy analogs that could carry over. And as I've said, when I asked Adam my first question, I wanted to know what the rate of abuse was. From what I heard, I thought it was stunningly low. And so at that particular point, I think that the old distinction that you make about the different standards for getting access to connections without content is extremely important to make. I think when the Chief Justice went the other way in one of these cases, I thought he was wrong. If you can trail somebody with 10 people and dilute your police forces, on the other hand, if you could follow them by chasing a cell phone from a tower and get the same thing with higher accuracy and lower cost, it seems to me that that makes us a safer society rather than a more dangerous society. And so I'm perfectly happy to live with this. Years ago, I wrote an essay on substantive law called The Static Conception of the Common Law. And the basic principle was if you knew your Roman law pretty well, you know your common law pretty well today as well, that the level of transformation that you need in doctrine as a function of technological improvement is generally speaking fairly overstated. And I do kind of think that, having listened to the discussion today, I would think that that view is actually, I hold it more strongly now than I did before the conversation began.
I wonder, Richard, I wonder if you would treat the instance of what's variously been called tracking or crowd surveillance, if you would treat that differently from the traditional criminal investigation. Now, my understanding from the vendors that I've talked to and from the law enforcement people is that the technology is not there yet to do real-time crowd tracking with any degree of accuracy, but it'll probably get there. So should we think about that differently, or is that the same?
No, look, what you're saying to me is you've got a wildly unreliable technology. There's going to be a real barrier to its use because you'll get too many false positives. That will lead to a dissipation of resources. What happens is, the way I would do this is, if you've got a weak technology, you basically rely on it only in cases in which it seems to yield highly confident results. And then as the technology gets better, what you do is you start to expand its sorts of situations. But the basic intuition that Floyd put forward, that I put forward, is when you're running dragnet searches to try to find out who is going where, that's the last time you want to have anything that looks remotely like a warrant requirement. It's only after you got some kind of specificity about a particular person that you want it. And at that point, you don't want to cheapen the probable cause standard. And one of the risks is, if you say you've got to get probable cause for these dragnet type operations, and you're going to cheapen the standard, then you're going to carry it over to individual cases where I think they're real abuses. So the way in which I see the thing is, having taught criminal procedure a couple of times in substantive criminal law and so forth, I can tell you individual cases that I think have gone wrong. But I think the basic intuition of saying that so long as the situation is fluid, you don't worry very much about the warranty requirement. Once you get it stabilized and you know what your target is, you take it very, very seriously, is, I think, a long-term viable solution in this particular area. And I haven't heard anything today, at least for the United States, that would lead me to go otherwise. I mean, I appreciate everything that Stephen said about using these technologies in China. I wouldn't trust those guys with anything, right? The only thing that will solve the Chinese problem is a revolution. And that's not something that we could sort of bring about at this particular point in time. But I don't think we're here in the United States that. Let me give you one example. I do recall when they did the phone, old style sources, what they did is they miscoded 202 as 20, and they thought they were chasing after Egyptian sources rather than Washington, D.C. And the moment it was disclosed, everybody inside the agency did everything that was humanly possible to destroy the last bit of evidence that was collected under a legal situation. And if you get that kind of institutional response by way of correction through an agency, I think it's a terrible mistake to try to put all sorts of ex-ante kinds of controls upon them, which will in effect lead to higher crime rates. And as we know, those also have disparate impact by race. So I think in effect, if you've got the basic balance, you keep it in this way, and then you try to figure out how you run your intelligence, artificial intelligence, within these traditional parameters. I don't think you'll go too far wrong. So that's where I come down. I'll be quiet for a moment, at least.
And Adam, it seems to me that your position is that the sort of particularized scrutiny that Richard's talking about does not protect against the harm that you think occurs from a wider use of the surveillance technology. And I'd like to ask you to elaborate a little more. I thought what you said about the minimization idea in the crowd monitoring context, I thought that was very interesting, and I'd like to ask you to elaborate that a little more and perhaps spin out some different scenarios of crowd monitoring and tell us how your concept of minimization would work.
Yeah, I mean, again, to be perfectly clear, crowd monitoring, dragnet face surveillance of groups of people is, from our perspective, the greatest harm, definitely should be banned. From our perspective, minimally needs warrants and minimization rules. I do just want to pivot slightly and address a point that Floyd has made and that Richard has made, which is whether or not change in technology requires change in the rules. And precisely what the Supreme Court has said in the Fourth Amendment cases of Jones with the GPS devices and Carpenter with the cell site simulator, the cell site location information, is that yes, new technologies do require greater protection. That to say that it doesn't make a difference, that it does make a difference that to track someone 30 years ago required 100 cops, but to track someone today does not require any cops, is a game changer. And as Floyd says, you might have to hire 5,000 people to comb through 10 billion photographs that Clearview has collected in order to have as much information as you do with an algorithm. That is the same thing, that the technology has changed up the game. When the technology changes up the game, we can't just be following the same rules. We need to have new rules. That's what the Supreme Court did in Carpenter by saying there's still a reasonable expectation of privacy when you walk around with your phone, even though the phone company has your information. So this face surveillance is a game changer that requires a whole new set of rules compared to taking photographs of people, looking with our eyes at people's photographs, or having police conduct, old shoe leather surveillance of people.
But new technology, seems to me, is always suspect. When Kodak came out with the box camera in the 1890s, it was the first time that people didn't have to go to a photographer to have their picture taken. The masses could have cameras that they carried with them. And there were protests about the fact that somebody could now take a picture without consent of somebody walking on the beach. The New York Times had an article pointing out that people in Newport were appalled and referred to the people who had these new cameras as Kodak fiends because they were taking unflattering pictures of women without their consent. We get used to these new forms of technology and we come to live with them. That doesn't mean all of them serve the public. I'm not making that argument, but I do think we ought to be careful about supposing or presupposing that because it makes it easier to examine large crowds, it's therefore more likely than not to be dangerous.
Thank you. Stephen?
I want to just sort of make sort of 2 points. So one of this is question about that Richard made a little earlier about whether it's just a China problem, and we can otherwise at least rest assured, certainly in the United States, that this isn't something that would potentially represent a challenge to civil liberties, privacy, and so forth, as long as you have the right protections. And I would say, I think on a basic level, it's much more than a China problem. I mean, if we're lucky, we can say that amongst a very small group of liberal democracies, you may have some of the right regulations and accountability structures in place in which to deal with potential abuses arising from the use of facial recognition technology. But in the vast majority of the world, this includes many democracies. Let's look at the largest democracy in the world, India. The abuses are fairly prevalent and they're increasing. So I think, first of all, it is something that we should think about as an issue far more prevalent than just a handful of authoritarian countries. I think my other sort of concern is when you look at bulk collection, mass surveillance in the context of the United States. First of all, there is a fairly long history of abuse associated with law enforcement and intelligence agencies improperly accessing records otherwise against individuals, for dubious motives, for dubious purposes. I don't know that I mean, you can think of lots of use cases where in the United States, in different jurisdictions, police abuse of material information that's collected, whether through drone surveillance, CCTV, intelligence video cameras, or otherwise, is used later on for bad intent. I think what's particularly interesting with this technology is that when you pair it with powerful algorithms, with the amount of data that is out there about particular individuals, it really leads to a transformative effect. It's not simply a camera that is recording views. You can now, as Richard Clarke mentioned, there's a fusion capability where you can bring together different databases of information about an individual and come to new insights and potentially lead to new types of abuses. And so I think that's not that you want to necessarily ban the use of this technology, but we want to be very careful in terms of, what kind of regulatory structures are in place, what kind of protections are available, and not to jump too far ahead where you deploy and ask questions later after the abuses have occurred, as opposed to sort of being very careful about what kind of potential precedents are being set by deploying mass surveillance and pairing it with algorithms and fusing different databases of information, and then wondering why there are abuses that occur.
Yeah, could I comment on Carpenter? I regard that as perhaps the worst of the Supreme Court decisions in this entire area, precisely for the reasons that I said. I see no reason why you want to put a squadron of people trying to chase somebody down, have a high error rate, when you could release people by doing the technique of trying to locate those with their phone. And then after you do that, collect the kind of evidence that you need for trial. So I think, in effect, the Chief Justice was completely wrong in what he did, and that the old Bell case, which said you could put these things together for location, was the right decision, and that it sorts to carry over. And, I'm willing to cite Supreme Court authority when it seems to me, but I think in the normative debate, the fact that the Supreme Court has come out one way or another is just a data point. I don't think it has any independent persuasive stuff. And I regard that opinion as one of the worst opinions ever written in this particular area, because what I think it does is it treats unreliable data collected by very expensive means as being better than reliable data being collected by much cheaper means, and that is not in the interest of anybody in the long run. We will catch more criminals and have a lower error rate if we don't follow characters than we do. And if you're a libertarian, a classical liberal as I am, catching criminals is a positive good. I mean, because what it does is it protects everybody else in society. Oh, I'll take my hand down.
I'm not seeing any hands up from the audience. So if members of the audience are wanting to ask questions, make your desires known by shouting out.
Okay, thank you very much. So yes, I've really enjoyed the conversation. And I think it's a very tricky balance to strike, for sure. I have a question, really to no one in particular, but anybody wants to tackle it. So I guess one of the underlying issues here is technological determinism, and to what extent we believe that this technology, AI, and its use is inevitable and will sort of come to dominate in decades to come. And so one of the aspects of this is the use of publicly available data, including publicly available facial data from smartphones and so on. Like Floyd mentioned, everybody has a smartphone now. Everybody's posting things on Facebook, Instagram, and as the AI tools become more powerful, this data can be used in surprisingly powerful ways. And so people should be very careful in what they post, I suppose. But one question is this: if every person with an internet access will soon be able to use advanced AI tools, in many which are open source and not proprietary software, to extract and manipulate publicly available information, including facial recognition data, does not the attempt to completely ban or regulate such technologies appear as a Sisyphean task? And what sort of worry should we have when these technologies become so powerful that even publicly available photos, holiday photos, and so on can be used as key data for making inferences about people's private lives and so on.
Let me try an answer to that. I think the use of AI is increasing exponentially. It's already influencing a lot of things in your life that perhaps you don't even know. Every time you use a credit card, there's an artificial intelligence program that's trying to determine whether or not it's fraud. AI is everywhere. It's going to increase in its ubiquity. Should we regulate it? Yes, we should. It can be abused, and facial recognition can be abused. We should regulate it as well. Can we regulate its use by the private sector? That's going to be harder, although I think in the area of financial regulation, we're already seeing steps to regulate the use of AI by banks because it's been misused by banks. And not intentionally, but it has resulted in redlining. It's resulted in racial discrimination decisions regarding loans and whatnot. But I think we can at least say with AI and facial recognition, the other related technologies, we want to regulate what the government does. That I think we should all agree to. And we want standards that are universally applied and that are transparent. Then we should also think about what are the private sector utilizations of these technologies that the government has a public interest right to regulate. In some areas, I think we'll find that, like loans, banking activities, there is a public interest right to regulate. So in answer to your first question, is it inevitable? Yeah, it is. These are not technologies that are going to be rolled back anytime soon. They're going to be used with increasing frequency, which means we need to get on the stick and get public standards going sooner rather than later.
Louise Papke has posted a couple of comments. I didn't, they weren't in the form of questions, so I didn't read them out, but I'll summarize. One comment was that in many situations, consent is not really all that voluntary, and so we should prefer opt-in to opt-out. The other comment was in response to Professor Epstein that the possibility for dissent may be more of a social good than catching criminals, and therefore efficiency might not outweigh other considerations. So clearly, Arleto, you had your hand up, I think.
I just asked a question, but thank you very much.
I think Max has his
Yeah.
hand up.
So I have a question that's sort of lurking behind all of this, which is a kind of pet issue of mine that I'm very curious about all the time, which is what's the value that Americans place on their privacy? So we've been talking about sort of the government's needs here, but there seems to be a disconnect between how academics and law professors talk about how Americans feel about privacy and how Americans actually act with respect to their privacy beliefs. Because, if it really is the case, if it's really the case that we care so much about, being exposed online, people would not be posting the things in public that they post. And so on one end of the ledger, it seems to me that performatively, we really don't care about privacy all that much. And we would care more about solving crimes. But what it seems to me like is we don't like the ick factor, the ew factor of knowing that there's a database out there and sort of knowing that it's going to be used. If it's so out front, we don't like it. But if it's gone on behind the scenes and we don't know about it, we're basically fine with reaping the benefits of it. So I guess my question for the panelists is, how much do people actually care about privacy?
I think you make a very good point. I mean, people who, who drive on bridges and have to pay a toll can assure their privacy by doing it piecemeal, paying cash each time. But if anybody watches Law and Order as often as I do, he learns how easy it is for the police to use the data that is collected when you, in effect, buy 20 at a time and check in, because that sort of information is perpetuated and used.
It's also the case every time you go through the easy pass to get your car license. Look, I think the time is 1:20, if I'm not mistaken, right?
That's right.
And Ajan, if I'm mistaken, I think we sort of have a contractual obligation to keep to the limits. And so I guess at this point, thank you so much for being our stalwart moderator, Hank. I'm going to just say fair, fine, well, let me just make the one kind of obvious comment, a couple of obvious comments at the end. One is it's always a sign of a good debate, particularly with a strong group, when you leave with people still kind of thinking that it's extremely important and that they get other points in. This is a maxim that you learn from show business, is you always want to leave the stage with somebody wanting more rather with them wanting less. I think that's the first thing. The second thing that I want to say about this, I think tails on this is a highly contentious issue in which there are very deep divisions, I think, which were fairly represented and fully exposed here. One of the things that has been characteristic of too many arguments in too many forums, unfortunately, some of which I participate, is that substantive differences lead to massive degrees of vituperation, which I think have no place in academic debates. And so what I think is extremely encouraging, and for which I want to thank everybody on the panel, is that I think civility and cogency and germaneness was maintained throughout. The purpose of discussions like this are twofold. We try to persuade each other, but also I think what we try to do is to reach a larger audience so that they can become more informed citizens when they try to make their choice. It's very clear when you listen to a debate of this particular sort that trade-offs are an essential feature of democracy. It's very clear when you listen to a discussion of this sort that inevitability in terms of technological advances is always going to play some kind of role. It's always clear when you listen to debates of this particular circumstances that you can never be sure whether the rules that applied then could apply now, the rules that apply to public operations could apply to domestic private operations, rules that apply domestically or rules that could apply internationally and so forth, or rules that require enforcement ex post as opposed to those ex ante. So what happens is we get a debate in which there's so many dichotomies that have to be addressed that it turns out we're keeping many balls up in the air. And we have, I'm happy to say, an extremely informed panel talking about all of this stuff, keeping these balls moving. And so as the time draws close, what I'd like to do is to thank everybody for all that they have done in order to make this thing work. And I hope that we will consider, that everybody will follow this up. There's much litigation that's coming down the road, much technological innovation, much regulation, much public discourse, and that we were a part of it, I think, is to our credit. And so the Classical Liberal Institute, which believes in moderation on all things having to do with discourse, I think we thank you. I think Mario and Ajan, I'd like to thank Ajan for helping organize this thing, and for Max Raskin for getting it to us to talk about this particular issue. So thank you for everybody, from everybody under these circumstances. So here's a kind of a gentle round of applause, okay? Thank you all for coming.